Welcome. My name's John Broom and I'm the chair of the Contracts and Procurement SIG. This is the second of 3 webinars on lessons learned from the Carillion collapse part 1. The first one was largely by Philip Rees, a little bit by myself. The YouTube video is up and the slides are on the SIG Micro site. The third one is on May the 30th, and that is by Alistair Greenham, and he will give some tales of his experience where managing an $800 million site where 2 contractors started to fail on him. So he'll talk about the early signs, what you try and do as they are failing, and what you do when they are failed and become insolvent, and give you the benefit of his experience. So this is the second. So you haven't followed webinar 1 and you've ended up with a financially, or you look like appointing, despite your best advice, a dodgy supplier or provider. But there are certain things within your contract which you can write which don't necessarily avoid it happening, but protect your position, reduce your exposure. And I'm very pleased that Sarah Schütte is back with us. Last year, Sarah did a series of 3 on basic contract law for project managers, which were very well received. And she's back now to do one on top 10 things to put in a contract to protect your position. So with that, I will hand over to Sarah. Enjoy.
Thanks so much, John. Hi everybody, good afternoon. John, thanks so much for that really kind introduction. I'm absolutely thrilled to be back working with APM and the rest of the SIG committee and group that we have going, really strong group of really enthusiastic members. So it's an absolute pleasure. As John said, this is the second in the series of 3 webinars, all to do with insolvency. And I have the pleasure of being able to talk through a few things in relation to contracts. Anybody who listened in last year will have got a sense of the passion I have for contracts and for making them effective and useful for people. And there's nothing more needed in terms of its effectiveness and usefulness than possible insolvency, because it's so upsetting to projects. So what we want to look at this afternoon is how insolvency affects projects in terms of the insolvency risk, and also in terms of the insolvency impact. And you're going to hear from me quite a lot in relation to that pair of things. It's a little bit like the pair that you have of project procurement and project delivery. There's some really strong links between the two. So I want to look at insolvency risk and insolvency impact together. As John said, and as a bit of a sweetener, I want to give you my personal, in my experience, top 10 ways to ensure that you have a contract which is a really effective and useful one, and which is going to give you as project managers some measures to try to protect your project from the effects of insolvency. I will do a bit of a wrap up at the end, and again, as John mentioned, you get an hour of CPD points. I will say up front, all the slides are going to be available, and this slide deck is pretty full in terms of its content. So enjoy, sit back, listen, don't worry to make any notes. It's all going to be in the deck, which you're going to see coming up in front of you on the screen. So I hope from a pragmatic sense and a bit of know-how for you going forward, that will also be helpful. Very happy to share that with you all. Now, just by way of background, some of you are quite familiar with me and my company. Those of you who aren't, I'm going to show a slide now that I used in the webinar series I did last year, which is why I'm doing what I'm doing with APM. My core belief and the vision of my business is about the reality of using law in practice, of applying that law in a very pragmatic sense to your project as that project develops and as it realizes the benefits and gets towards a delivery conclusion. To my mind, and many of you know this already, project managers are central to smooth running of projects. You guys have to juggle an awful lot of things, and you need to be multi-skilled. The parties to those projects, the legal parties to those projects, depend on you to administer and to manage the contracts and the project, and to give direction to them as to what and how and when to do things at certain times. So, of course, project managers should learn all about contracts. If you don't learn about contracts, the project, of course, becomes at risk, or the project delivers subpar, so it doesn't deliver all the things that everybody wants it to set out to achieve. And of course, in a project management sense, as a professional delivering services, you yourself and the organisation you work for are somewhat at risk. So there's lots of good reasons for project managers to know all about contracts. I wouldn't be a lawyer if I didn't put this caveat at the end. Do get the basics, but do also be aware of your limitations. None of the work that you do in those multi-skilled areas is about turning you into an expert in those multi-skilled areas. It is really about getting the basics right and then knowing when to seek help. So on that note, let's have a look at how insolvency and threatened insolvency affects projects. Well, project managers, of course, are dealing with contracts every day, and we depend on contracts to help us deliver our projects. That's a real foundation for learning. Insolvency or suspected insolvency is really threatening and undermining to very real relationships, the people on the projects, but also the legal relationships between the parties, so the contracts that bind them together. Projects which are at risk as a result of insolvency have a certain fragility to them. They are vulnerable to collapse at any time. That probably sounds quite dramatic, but you can see very quickly in projects where there is threatened insolvency or actual insolvency, and it doesn't matter how slowly or quickly it comes, you can see the cracks start to appear in those personal relationships and in then thereafter the legal relationships as well. Now, you may not, as a project manager, be able to actually do much to stop the insolvency. You're not a superhero, you are there to deliver the project, but you're not entirely helpless. So this webinar is all about upping your commercial awareness in respect of insolvency and threatened insolvency. And as you know, we have based this series of webinars around Carillion, but we're also now seeing in the market a number of other high-profile collapses. Those are very shaking to the market. They do bring a certain fragility to the market itself, right from top to bottom. At the same time, there is still in the market a lot of consolidation of firms. You'll have seen high-profile mergers and acquisitions and other partnerships coming together, and those two things coming together at the same time as very fierce competition and low margins really make for quite a tentative and fragile market. So the more we can do to protect the project from the risk of insolvency and thereafter the impact of insolvency, the better. One way we can do this to help project managers do their jobs is to include provisions in the contract. So we're talking about what can we do at pre-contract stage, at negotiation stage, as well as then at delivery phase, looking at raising the awareness for those indications that are coming, those threats that may be on the horizon. And of course, from your perspectives, a good contract is going to enable you to do your job better. So let's jump right into the top 10. I will say it's not official, it's mine, it's my experience over my years of practice, and I hope that what I'll impart will be useful to you. It's not the Holy Grail, and there may be others who have other ideas as well. But these are the 10 things that struck out to me when I was writing this, when John asked me to get involved and to join with the gang to bring this webinar series. So We'll go through those one by one. They're not in any particular order. It's not a case that number 1 is more important than number 10. It is just 10 things which I think are useful to you to look at, to consider, to think about, to maybe go to one of your projects this afternoon, have a look at the contract and say, hey, what have we got in relation to any one of these 10 things? So my first tip for proper contract clauses that are going to help against the risk of insolvency and the impact is having a proper payment clause. Now, many of you know, I'm sure, and will activate this in practice, that under the Housing Grants, Construction and Regeneration Act, the practices of pay when paid and pay when certified are not permitted. However, we all know that they still go on. What can you do? Well, what you can do is to stagger your payment cycle dates to make sure that you are juggling the payment requirements and complying with the Housing Grants Act, that underlying overreaching piece of legislation. So stagger the payment dates to make them work so that you are kept as neutral as possible. If you're in one of those contracts, you're paying down the line and you are receiving money from up the line. However, you need to be careful with this because you don't want the start to end date. So your starting date, of course, for your payment clause is what's the due date, and your end date for the payment clause is what's the final date for payment, which are the two statutory phrases that are used, the end to end for the payment cycle. Don't make those too long. If you make them too long, it puts too much pressure on the downwards cash flow. It might feel good to have long payment dates and extended payment cycles, but the reality is that it puts increasing pressure. So the pressure is somewhat there at the beginning of the project. By the time you get to the end of the project, you've got quite a pressure cooker on the cash flow. The other thing to note, and it ties in quite well with the Housing Grants Act in terms of an underlying piece of legislation, it's an underlying code of conduct, is the Fair Payment Charter. So we want the public sector to lead by example. So those of you who are for public sector clients, please see if you can lead the way in reducing the undue pressure on that cash flow down the line, not making the payment cycle dates too late. If you are in public sector contracts, you will need to abide by the charter. So you need to be careful about how you stagger those payment cycle dates as well. But all in all, my advice would be make the payment cycle date staggered. Yes, there is a reality to moving money up and down the line, but don't make it too long because there is a tangible increasing pressure as you get further through the project, and that's not released for a very long time afterwards. Right, item 2 on my list is to have some security contracts attached to your contract delivery, and those come in the form of performance bonds and parent company guarantees. Now, the whole point of these additional contracts is to secure performance from reliable third parties. So they're not people who are involved in the day-to-day delivery. They are people, by which I mean organisations, who are sitting in the background, ready to take over if the need comes that the party who has to deliver is insolvent or is threatened with insolvency and has to step out of the picture and can't deliver anymore. So you want to have these contracts in place, you want to make them enforceable, and you want to make them practically realistic. So it's all about doing your due diligence to make sure that that third party who's got to be ready to step into a contract and perform is going to be reliable. Another practical matter I would make in relation to these types of contracts is that the delivery of those contracts, the entering into them, so in other words, getting a signed copy of it, ought to be a condition precedent to payment. In other words, any payments which are due to the contractor will not be paid until those documents are delivered. And there's a reason for that. It's not to keep the contractor out of its money. It's to start the project off on the right footing, to make sure that we've got that security of performance in place and ready, anticipating anything that might come along. So the quicker that those documents are entered into, and the condition precedent is satisfied, the quicker we can then get on with the project. And it really ought not to be a problem for contractors to get hold of those documents. It will, of course, form part of the tender process, so everybody knows that they're going to be requested and required, and they've got plenty of time to get their reliable third party lined up and signing those contracts. Right, my third item links in with those contracts as well, and this is a particular clause of a collateral warranty called step-in rights. Step-in rights are a specific term. They are found within collateral warranties and not usually within any other forms of contract. And typically it's a clause which is found in subcontractor warranties which are given to employers or clients, and it's also found in collateral warranties which are given by the main contractor in favour of the funder. So if you remember, with collateral warranties, we are creating additional or sideways contracts which get round a leak in the contractual matrix. Okay, so subcontractors jump beyond the main contractor to the employer, and main contractors jump beyond the employer towards the funder. So those are the two forms of collateral warranties that commonly find these step-in rights, and I would encourage you to check and see if you have those on any of your projects. The whole purpose of step-in rights, as I've hinted at, is to be able to leap beyond the person whom you're in contract. So it enables the beneficiary of that collateral warranty to very quickly take practical control of that performance. Now, that person, in reality, the funder or the employer, is going to have their own preferred provider. It's a bit like having that reliable third party lined up. The funder, the bank to a project, isn't going to become a main contractor and start building things. That's not its job. Okay, its job is to provide investment, to provide value for money for its shareholders, etc., etc. So the funder is going to have its own contractor come in, step in to the project to take the place of a main contractor who's gone bust or has been taken off the job for insolvency reasons, and then the job can continue. And the whole point of having step-in rights is speed. You want to keep the project going. You don't want the project to be delayed any longer than it has to be by legal wranglings of who's going to take over, who's going to do the job, can people continue, can the subcontractors help, etc., etc. So the whole point of step-in rights is to keep delivery going, to take control quickly, and to avoid unnecessary delay. Okay, moving on. Item number 4, another clause that I want you to check out in your contracts is all to do with termination, which sounds quite down, I admit, because insolvency risk and insolvency impact have a very practical impact in terms of how a contract is going to be delivered. So you need to have a termination clause in order to bring the contract to an end. In a very practical sense, have a look in your contracts and try to include a right of the commissioning party to immediately terminate. In other words, there is no notice provision, there is no procedure that has to be gone through. You just need to serve the termination notice and off you go. Again, that sounds a bit harsh, but there are situations where you need to take that contractor straight off site and start making arrangements for a replacement contractor to come in. Now, in addition to that right to immediately terminate, you want to include all sorts of insolvency procedures that are covered, because there are quite a few different ones out there. There has been a consolidation of insolvency law since I was studying it, and thankfully things are quite a lot more streamlined now, but there are still quite a number of different procedures, so you need to make sure that they're all covered off in the contract as well. As a practical matter, of course, exercising that right to terminate needs extreme care. It's not going to be something that the project manager is going to be doing, but the project manager can most definitely advise the client who is considering exercising the termination right on the very practical options and any of the timing impacts that might affect the termination. So whereabouts are we in delivery phase? Is there anything critical which is coming up which is going to be completely messed up or delayed, or huge impacts on other areas of delivery or on subcontractors, etc. All those kind of things. You know, if we terminate, how is the land going to lie thereafter? So getting rid of the contractor and putting another one on board is one thing, but it's the ripple effect on the rest of the project that you need to be careful of. And that's where a project manager can definitely add some value to their services to the client. They're in a position to be able to talk to the client and say, hey, if you exercise this right to terminate, do you realize what will happen? Let me explain where we're at in delivery phase. So you need it. You need to be able to immediately terminate, but you also need to be careful about when and how it is exercised. Right, item 5 on my list is another clause of the contract. This may be one which may seem a little bit obvious, but it is definitely something which needs to be checked when we're talking about insolvency. And that is the law and jurisdiction clause. If you're doing UK contracts in the UK with UK parties, you're going to choose one of the 4 jurisdictions of the UK. Okay, so they are, I've said this before, but people routinely think we have UK law. We don't. We have English law in England, Scottish law in Scotland. Wales take on English law with a few bits of their own. Okay, so there's some specific Welsh law bits, and there is Northern Irish law as well. So do think carefully about which law and jurisdiction clause you need and pick the appropriate one for one of the 4 of the UK. Here in England, we're going to be looking at contracts to include a law and jurisdiction clause which has English law in it, and we want the courts of England and Wales to be the courts that have jurisdiction of any disputes. Jurisdiction is all to do with the power to decide, if you like, the power to determine what those contracts are all about. On a very practical level, your projects, depending on their size and their complexity, may well be using plants or equipment or bits of kit which are coming from outside of the jurisdiction, outside of England even. So if you're taking things from Scotland, there may be a Scots law impact, for example. We tend not to think of that, tend to think more of outside of the UK, but just be aware of those 4 jurisdictions questions as well. It's really about the pragmatism of having to be a creditor chasing money from overseas jurisdictions, so from countries that are outside of the UK or one of the 4 jurisdictions of the UK. So make sure that you have in all your contracts to do with the project a law and jurisdiction clause which confines the dispute or the chasing of the money, if you're a creditor in insolvency, to English law and to England and Wales, because it's a right pain, and every country has its own set of insolvency procedures, and you may find that these take an awful long time and are horribly expensive and time consuming if you are having to try and get your money back from somewhere overseas. Linked in with that is my 6th topic, which is to do with intellectual property and title to items which are going to be included in the project. So this is a contract clause that you can usefully look out for. It's becoming more and more of an issue in my experience, and people are getting more and more interested as to the question of when does title pass? In other words, when does your ownership of a particular item pass to you? You may think as the employer that anything which is bought in relation to the project is yours. Well, it's not until you either satisfy a contractual clause or you pay for it. So have a think about when you need that title to pass. There's a few examples up there in your slides. The common one is once the item is incorporated into the works, that becomes yours because it's part of the works and you're paying for the works. However, you might try to extend that to include items which are in storage. In NEC terminology, we have the working areas, and there are specific clauses in the standard NEC, and those are often changed, I have to say, to talk about when title passes when items are brought into the working areas or are stored within the working areas. So if you're in NEC territory, go have a look at that section of the contract as well. The simplest thing to do, to my mind, and again, goes back to our vision as a business of making law really practical for people. If you want title to pass to you, pay something. Okay, gain that legal interest in the item by satisfying almost a reimbursement type of clause. Okay, that's one way to get the title really quickly. And linked into the point about jurisdiction, just be careful about how much supplies or materials you're getting from outside of the UK, because other laws may apply. So tie in those things on title and law and jurisdiction at the same time. Very pragmatically, if you can't get that piece of kit, or it's stuck in the dock, or the supplier in some other country has gone insolvent, where are you going to get it from? How long is it going to take? What impact does that lack of item have on the rest of the project? Is it very integral? Is it on the critical path? Some very straightforward and basic things can really send the project awry. So be really careful with the IP and the title clause as well. Right, item 7, we come back to finance. So it's both a contract clause matter, and it's also a matter of very practical impact. One of the things that you want to do as a project manager is to make sure that you are managing the delivery and getting that right balance between certifying monies which are due and making sure that money doesn't go out of the project too quickly. People are worried about cash and cash flow, and as we've seen with Carillion and with other companies as well within the industry, when companies go insolvent, there is a scrabble around for cash. One of the ways that you can protect your project is to include contract clauses which ring fence project money. And the idea behind this is to ensure that that money doesn't just disappear into general bank accounts, and general bank accounts are the ones that, surprise, surprise, get emptied very quickly and drained. So if your project money is protected in some way and not in one of those general bank accounts, then you may have a fighting chance of giving the project some cushioning against the impact of an insolvency. In practice, my experience is that this is particularly a problem for those at tier 2 and below tier 2. And they get a bit of a double whammy because they're also hit with those long payment periods and those cycles which are staggered in not quite a balanced way. So they have very long start to end dates, such as I mentioned, trying to avoid in topic 1. So poor old tier 2s and below have that double whammy applied to them. One way to solve this is to include contract clauses which insist on a project bank account or some form of escrow. I have also seen them as a trust, which is taking the concept even further. Whichever form of protection or ring fencing you choose, it's going to cost money, and it's going to cost money because there's an administration and checks and balances aspect to it. You can't just dip into a bank account, you can't just take the money. There are certain conditions that need to be satisfied, there are certain steps that have to be gone through. So there is an administrative and financial impact to the operation of a project bank account or to an escrow account. But I do think it's worth considering. My thinking is developing, and some of you know my thinking is quite creative on these things. My thinking is developing into it being something which is an investment in the project. So it's not just something which one party thinks is a good idea because it's going to protect it. I actually think that across the board, it's the kind of principled concept that industry could and perhaps should embrace more often. The financial costs of operating that account, I think, are a good investment. There is a bit of administration and management attached to that, so it is another layer perhaps for project managers to have to think about, and you might well need some support in making sure that the account operates properly, that the steps that are taken are done so properly, etc. But do think about it as a very practical matter, which is going to protect not only against the risk of insolvency, but the impact of it. What happens when insolvency actually lands in a project? Right, my 8th topic is to do with insurance. So insurance, we have it as a contract clause, and we also have insurance as a practical matter. Everybody wants themselves to be covered for the financial impact of delay in progress of any project. The practical side of that is that if you do have insurance and there is delay to a project and the insolvency impacts that project, then whilst you whilst your insurance claim is being processed, you may be able to secure some funds from your insurers in the meantime, and that could be really, really helpful just to tide you over and get that project kick-started again, because there's inevitably going to be some delay when insolvency hits, or when insolvency is threatened and everyone starts running around trying to solve things. Insurance is not really readily thought of at that stage, but there are insurance products on the market which can give some protection against that, and in the very short term can provide some funds to ensure that delivery continues. If we have to have a period of overlap between a finishing contractor, for example, and the mobilization of a replacement contractor, so you've got some overlap, there's sort of double prelims, double costs, there is some duplication in effort on the professional services side, then the insurers can take care of that and then can process the claim once the project is then stabilized and the replacement contractor is in place. So make sure that those kind of clauses are in the contract, and then also just be aware that as a very practical side for project managers, this is something which may be able to help you when the insolvency wobbles start to come. Okay, next on my list is another check and balance feature, which it's really useful to write into contracts, and that is to have the professional services of a project monitor. So this is going to be a combination of your contract clause and also a professional services contract to engage that project monitor and to put them in place. For me, this is a role which is all about value versus spend, and trying to get the most out of that person by making sure that their engagement has the right kind of obligations in it. It gets them to balance out that value versus spend question. In other words, to have a look at carefully the benefits which are being realized, how much value the project has attained, the value for money question, and to use the public sector, as against the money which has been signed off as being due, or the money which has actually been spent, which could of course be quite a lot more. So getting the professional services contract in place to really squeeze out the most value from that person to support the project manager. It isn't you, you're not the project monitor yourself, so you're going to have to work alongside that project manager and to get their support and their buy-in to that question of value versus spend. I have made a footnote there to say that it's not something which is just for funders and investors. It's the kind of professional services which is nowadays often engaged by funders and investors, because they are to some extent hands off the project. They're not on it every day. They do have a percentage invested or cash invested in the project, and they want to know how their return on investment is going. To do that, they will engage the services of the project manager, who is going to help them to work out how much money they've put in versus how much value they're getting out of it and when the return on investment is going to come. But it's also a really useful professional for the project manager to have to hand. You're going to be working alongside them. You can take their advice on some of the questions of value versus spend, and that will also then help you in terms of the certification and the payment advice which you're giving to your client as well. So there's a real value for money question for you to get out of the project manager as well. Right, my 10th and final tip is another combination of contract clause and professional services contract, which I hope will be useful to project managers in managing and administering their projects. And that is the role of a contract administrator or an NEC supervisor, which has a very specific meaning. Those of you who are in NEC territory will know that. And this role is centred, or I want this role to centre on the topic of completion, because insolvency, threats and insolvency impact in terms of completion can be pretty serious. So first off, think about how you want to define completion in the contract. There's different ways of doing it, and the standard forms all have their own versions of this. Activity schedule is one of the items which NEC forms of contract refer to, particular versions of NEC forms, A and C in particular. If you're in JCT territory, then you may have contract milestones, so particular items of work which have to be achieved or particular stages of the works. And once those are achieved, then we say what completion means. Well, that's all very well, but you also need to be thinking about what actually has to be done in real life. What does completion actually look like as a real life thing? Yeah, how can we sign it off as being complete? In other words, what do we want to see? What do we want to feel? How do we want it to look? How do we want it to perform in order for completion to be said to have been achieved? And there's a real balance to this, and it's something that people don't tend to think about too carefully, but I'd encourage you to perhaps think about the projects you've got on at the moment. Maybe go away this afternoon and have a look at how completion is termed in your particular projects. Completion can't be so tough that it can't be said to be achieved. And if it can't be said to be achieved and we don't have completion, then we don't have payment, and that impacts on cash flow. And we already talked about the importance of getting those payment terms and the payment cycles staggered accurately and staggered in a balanced way so that cash flow keeps going. So we can't have completion being a really, really high threshold that cash flow is going to be under undue pressure. However, by the same token, completion can't have such a low threshold, or that so little has to be done, such that we have works which are not yet properly complete as being signed off as complete and therefore payable. And it links also into the value and the benefits issue. So, you know, what has been built so far, and is it any good? Can anybody use it? Does it have any value to the end user at this stage? We've all probably had experience of that pull and push of contractors doing lots and lots of work and wanting to be paid for that work. So they've paid their labourers, they've bought their materials, all that sort of thing. But actually the value to the client of what's been built is not the same. Yeah, a half completed wall of 1,000 bricks is obviously work that has a value to it, but from the client's perspective, it's a half completed wall, so it's no good to anybody unless it's fully completed. So that's the kind of practical balance that you need to try to attain, and this is where the contract administrator and the NEC supervisor in that quality assurance role can really, really help you as a project manager. There might be some technical niceties to completion which need to be achieved, I've got a couple of projects on at the moment in the water industry, and there are some little oddities that need to be satisfied in order to achieve completion. These are written into the contract so everybody knows about them, but they are steps to be achieved, and they are things that have to be shown and demonstrated in real life. So it's not just about building the thing, there's a performance aspect to completion as well. But as I say, make sure you've got that balance. It's not too tough because we need to keep cash flow going up and down the line, but it can't be so little that the client doesn't feel that there is any real value to it as they go along. And again, it's not you necessarily in these roles as project managers. You may not also be the supervisor, you may not also be the contract administrator, you may be a pure project manager just focused on the delivery. So a bit like the project monitor, even though you're not in that role, you're going to need to work with that person and work alongside them and take their advice so that you can then manage your your delivery and managerial functions in relation to the project. So those are my top 10. It's a bit of a whistle stop. I've got some other ideas as well, and some of that creative thinking I was talking about earlier links in with those. But for the purposes of today, I just wanted to give you those things which appear to be very real in my experience. So summary, and we'll then have some time for Q&A. So if you've got any burning questions, do start sending those in now. Watching out for those signs of impending insolvency. It's all about the stress to the people and to the project. Do make sure that you include in your contract clauses which are going to help you to manage that insolvency risk, and also then the insolvency impact. So we're trying to get the link between the theoretical risk of insolvency and the real life impact of insolvency linked together as well. And I would say again, do make sure you take advice from all of those around you. Insolvency is particularly fiendish. It's fiendish because the insolvency procedures are complicated and they can be very drawn out, and yet they need to be acted upon quickly. Insolvency does have real impact on the project and the people involved in it, so it becomes quite a team effort to keep the project going. As project managers, as I mentioned at the start of this, you might feel a bit helpless to actually do anything about insolvency. So it's really a commercial awareness point to just be able to go quickly and methodically into your contracts and have a look at what could happen next. Yeah, if insolvency hits, if this person has to step out of the project structure, who's going to take their place? How long is it going to take? How much is it going to cost? Who's going to pay for it? And as project manager, you are central to that question. And you are in a unique position to be able to advise and to support that project to keep going and to stay stable throughout the reality of the insolvency impacting. That leads me right into recommending to you to register now or soon after this one for webinar 3, which is going to be all about managing suppliers in insolvency. That's going to look at the very real impact of having to extract people from the project chain and getting in new suppliers. So do join us for that third and final webinar in the series. There are some questions coming in, I believe, so I'm going to turn it back over to John, who has been collating those and extracting the really interesting ones for us now to talk about for the next few minutes before we finish. I'd just like to say thank you for having me again. It's always a pleasure working with APM Contract and Procurement SIG. I hope this has been useful to you all, and good luck with all of your projects.
Okay, thank you, Sarah. First one is not on my list. Could you just outline the difference between a parent company guarantee and a performance bond and the pros and cons of each?
Yes, in a nutshell, a parent company guarantee is a special form of contract which is only given by a parent. Seems obvious, really, doesn't it? It is a guarantee, which is a slightly different form of contract from ordinary contracts. I like to think of guarantees as a one-way contract. So there's no real promises which are being made in one direction. The only thing that's been promised is, if this guarantee is called upon, if I get a phone call by the person who holds the guarantee, then I must come and do whatever the guarantee says I have to do with it. It works in just the same way as any guarantee you get on any item you buy, your new TV or whatever. It's a one-way contract. A performance bond is usually taken from a third party who is not connected to the person who's holding the bond. It can be a promise of performance, or it can be a promise of money to provide performance. So you get different forms of performance bond. As I said, it's usually a third party that's unconnected with the project or the organisations involved in it. Whereas a parent company guarantee is always going to be one of the an organisation which is linked to the party in question, either the direct parent, which is the ordinary position, or, for example, if you look at option X4 or the NEC contract, it's now providing for slightly more wider parent. They call it an ultimate parent company, an ultimate parent guarantee, and that one enables a parent up the line who's not maybe the direct parent, so someone else within the group, for example, to give that guarantee.
So, quick one from Philip. Item 3. Are standard forms of collateral warranty suitable to provide step-in rights, or are amendments required?
That's a really good question, Philip. Thank you for raising it. Standard forms of collateral warranties are available. There's various industry sorts, and some of them have optional step-in rights, which is helpful. It's a really good starting point. As with all standard forms of contract, you usually have to do something with them to make them appropriate to your project. Lots of you know my views on messing about with contracts too much. Have to say, standard forms of collateral warranties and even bespoke forms that I see in the industry with step-in rights in them are pretty similar. That comes with a big fat caveat to make sure that you read it before you get somebody to sign it. Because while 95% of the content of the step-in rights in the standard forms are the same, there are little differences between them. And of course, bespoke forms will do their own thing entirely, off on a tangent somewhere, often. So yes, start with standard forms. There are step-in rights available. Step-in rights don't come as standard. As in, you don't find them in every form of collateral warranty. You find them in those particular forms that I mentioned on point 3. So the subcontractor to client forms and the main contractor to funder forms. Those are the usual ones. You can also find step-in rights in standard forms from the contractor to onward beneficiaries. So, for example, somebody who's going to buy the project or who's going to operate the project after it's been completed and commissioned and delivered. So yes, there are step-in rights available in standard forms. Do read them, check them out, and make sure that they fit together with the project that you've got.
Okay, so we've got a number of questions around. Got one from Nathan saying, "I have not tried or have not seen an insurance that covers delay of the project. What is the extent of this insurance? Can you ask to cover the maximum liquidated damages or delay penalties? We don't have penalties in the UK, or a limited sum only?" And we've got another one which saying, is it really the name of the insurance? Is it just called delay insurance, for example? So there's something about terminology and then what you can actually get insured.
Right. Okay, so in very, very basic terms, you can insure anything you like, which is permitted under English law, including delay and including your own fault. Now, if you imagine trying to insure your own fault, that's going to cost you a fair bit. So we're not just talking about cover for liquidated damages. We're talking much, much wider impact. We're talking about the client not being able to use the project because it isn't finished on time. Okay, so whilst liquidated damages or delay damages cover some of that, and they're meant to, of course, cover what people commonly call, a realistic idea of. That's the sort of general ballpark that you aim at, and even that is a lot more complicated than you might think to get right in contracts. You're also talking about insurance products, which come under various names. So to address the terminology point, it's not really about what you call the product. It's really about what the content of that product is and what it covers you for. And you don't just go to the market and buy this stuff off the shelf. It's talking to the brokers and getting them to recommend a product and do some, well, I liken it to sort of semi-bespoke tailoring. So you've got a basic suit that you want to buy, and then you get it nipped and tucked and a different color lining added and an extra different sorts of buttons and things like that. So you start with a very basic delay product, and then you change the bits that you need for your actual project. There's insurance products on the market that will also help you to help you in the event that income that you want to generate or you expect to generate as a result of the project can't happen because of varying risk events. And if you define your insurance product to say, well, the risk event that might happen is insolvency, and then we won't be able to open the shopping centre, for example, it's one of the examples I give in my teaching, then the insurance will kick in and the tenant's rent that we're expecting to get in but isn't coming in because it's not finished, and therefore the tenants don't owe us any money. Those kind of costs will be covered as well. Does that help? I hope it does.
Okay, last question, I think, looking at the time, is I'm a project risk manager. What advice should I give clients for the amount of contingency they should hold? The cost of the step-in team, the cost of retendering for a newer supplier, plus the cost of delivering works. This could be a large percentage of the project value. Over to you, Sarah.
That's another really good question as well. And the answer to that is very much, it depends, and it depends on all of those factors actually that you've mentioned. If you do want to have all of those things lined up, and if you establish at the beginning of your project that actually this is the type of project which is financially fragile, it's perhaps a novel project, we think that this team is very overstretched in providing its services to us, we're having to get in a lot of components from overseas, all those kind of factors that when you put them together, you think, this isn't a run-of-the-mill project. This has possible deep repercussions attaching to it. It's a very exciting one. Everybody wants to work on it. But with a cold, hard project risk manager's head, you're going to start thinking, there are some warning signs before we've even started. So yes, do take all of those things into account. In terms of contingency, I suppose the question is how the client wants to deal with that. Do they want to actually have a pot of money that they just keep aside? Are you going to be going to the financial director or the chief accounting officer, whoever it is, and saying, yeah, we need you to put aside 50% of the cost of this project just in case insolvency happens? Now they're going to say, what on earth are you talking about? That's ridiculous. I think the more important thing is the awareness point of where the project could be fragile and vulnerable because of its particularities, and having a sensible plan in place. It's not really about having a pot of money ready, but more about being able to have the foresight of what might happen and the impact that this could be. And of course there'll be a financial impact, and of course there'll be an immediate drain on a pot of money which is put aside. Another way to avoid that pot of money being put aside is to have insurance backing. Okay, so you don't have to have that money there. You've got insurers to help you with that. You pay a bit more up front, of course, because you've got a premium to pay. But if and when insolvency hits, then the financial impact isn't felt by you as a client, it is felt by the insurers who are there to step in and to do their thing with their insurance product. So I think it's a very practical thing. And so for project risk managers, it's about the likelihood of impact. it is unlikely, I expect, that the entirety of your project on any of those project risk things is going to collapse in its entirety. More likely is going to be, have you got a good roadmap of what could happen and what the impact could be if any one of those events happens? And the answer to that might be, we need to have a pot of money, because if this thing happens, then we're just going to have to go and buy X, Y, and Z, or secure the emergency services of whoever, or rehire scaffolding, or whatever it happens to be. But I certainly don't think you need to start putting aside large chunks of 100% plus the project cost in real terms. That would seem to me to be a little overly cautious.
Okay, right. Thank you very much, Sarah. I'm afraid we haven't got any more time for any questions, so I'm going to call it a halt there. Thanks very much, Sarah, for preparing those slides, giving the talk, etc. I found it very informative. Goodbye.